Okay, good morning, everyone. This is Judge Kaplan, and we will be hearing the BlockFi matter involving Mr. Van Tubergen.
Your Honor, I at least cannot hear you.
There we go. Now, let's try it again. Can you all hear me?
Yes, Your Honor.
All right, and I can hear you all, so it's a plus. You never know Monday mornings. All right. We'll be hearing this morning's BlockFi matter regarding Mr. Van Tubergen. This is on remand from the district court relative to one issue as to allegations surrounding certain missing ETH. I've read, and I've received, and I've read both the underlying motion that was filed on behalf of the wind-down administrator, wind-down debtor, in effect seeking an adjudication of the merits of this issue and also alternatively estimating the claim. I've reviewed the two certifications that have been submitted on behalf of the claimant, and then there was a response by the wind-down debtor. So, having read all the submissions, I'm going to look for oral argument on the next step, which would be a continuation of the written arguments. So I would turn first, actually, to Mr. Magali's on behalf of his client, if he wishes the opportunity to respond to the wind-down debtor's reply. And if you want to add anything that's not in your papers, or otherwise respond, and then, of course, Mr. Ouellette, I would let you address any issues. But before we go there, are there any procedural issues the parties want to address on today's hearing?
Not from the wind-down debtors, Your Honor.
So let me start off correctly, as if you're all in court. Let me just have appearances for the wind-down debtor.
Good morning, Your Honor. Kenneth Ouellette of Brown Rudnick for the wind-down debtors.
All right. Now, for the claimant.
Good morning, Your Honor. Good morning, Ken. Joe Magalhaes, Eckert Siemens on behalf of claimant John Van Tubergen.
And already I'm going to start with an apology because I mispronounced your name, Mr. Tubergen. Give you a hard G, but I'll get it right eventually. All right. Counsel, let's follow suit in the manner I suggested. Let me hear on behalf of the claimant.
Thank you, Your Honor. So I knew I was up against quality lawyers in this case, Your Honor, so I was not surprised to find some arguments in the reply that do force me to address them. And I want to start with the integration clause because it's a tricky argument, naturally. And where I featured in my papers, it was in a particular context, and it was in a context of honing in on just the numerosity of the ETH. And I made the argument, Judge, that if you did a strict application of the integration clause in a manner in which, respectfully, we view the court as having done a very strict application of particular aspects of language of the LSAs, then that is how we would see the argument shaping up. Meaning, if you took the integration clause and you superimposed it over this dispute, over the numerosity of the ETH, then we believe the best evidence is the LSA. We would construe the emails as not trumping the LSA, as not being related documents for purposes of, it's not like it's an index or a schedule that would modify that term. And therefore, on the issue of the numerosity of the disputed ETH, Mr. Van Tubergen would be entitled to prevail. Really, though, Judge, for us, that was a worst-case scenario application, strict application of the integration clause. Our default position, I think we've made it clear throughout, Judge, is that we want all relevant and material evidence to be included and considered. Light is the great disinfectant I think we've been through enough ages of enlightenment to know that less information is never a good thing. And thus, that's our default position. We noted that the district court cited the integration clause, Judge. Previously, the parties in the court had not made a big deal about it. So I had to confront it. I tried to confront the nightmare scenario of a strict application. That's what I said. Additionally, I would say, to me, whether something's a related document is not synonymous or within necessarily the ambit of whether it's admissible parole evidence. So that's the other thing I'd say. Because really where all this is leading is naturally for the court to have a full flavor of what's going on, it should look to the emails. Because we made the related points that the emails in the subject line state reinstatement proposal. And I just want to get to that and accentuate that in a moment. But the point of integration clauses, Your Honor, is to uphold the integrity of contracts, not to result in a perversion thereof. And therefore, if an integration clause argument was taken to mean that everything should be excluded, you could only look at the four corners, that I think would result in manifest injustice, given what we know about the underlying purpose of the contract. And so without getting too academic, Judge, I don't want to ramble here, if there's to be a strict application and integration clause, we believe it would be isolated to the numerosity issue and result in just a knockout of anything but what the LSA itself says. But otherwise, our default position is, in the interest of justice, consider everything relevant and material, and in no way could the reinstatement aspect of the loan be disregarded, as that goes to the central purpose and genesis of the loan in question, and therefore a manifest injustice would result. That's contrary to the point of integration clauses in the first instance uphold integrity. And the other thing I would just accentuate, judges, and I know opposing counsel is excellent. They're going to make the best arguments for their client. We don't want anything to get lost in terms of the fact that, yes, a sophistication of ruling has been made against Mr. Van Tubergen, but he's still, relatively speaking, a common Joe, and he was a customer. And we believe that there's a lot of surrounding evidence as to BlockFi. This has nothing to do with their bankruptcy professionals. As recently as when Ken and I got off the phone on Friday, he was still trying to extend, accommodations. Let's say, being a gentleman. This is no aspersions against their professionals, but the entity itself, we believe, was doing a lot of, simply stated, shady things. That they're out there, they're in the public domain. Your Honor knows this entity as well as virtually anybody. And we believe that all of those surrounding circumstances, including their connection with other cryptocurrency giants, force them to be a little bit too eager to pull the lever on loans of individuals like Mr. Van Tubergen. And so, again, being faced with rhetoric, if I may call it that, as to Mr. Van Tubergen being, sophisticated or willing to engage in these high-risk loans, we don't want to forget the context that he still was an ordinary citizen. And we don't believe that what transpired is really his fault. And then also, as to the handbook, Judge, my client does fiercely believe that if that had been, presented as part of the debtor's lending documents, as my client fiercely believes they should have, that would have colored this entire matter differently and may have resulted in a different result in the first instance. But we're not trying to re-argue. As we introduced it, Judge, we see it as relevant in connection with our proposed third finding, which is that there was consequential damage as a result of the missing ETH not been there. And so if Your Honor agrees that the additional ETH should have been there, then we have to recreate what follows. And as we showed previously, for Your Honor, in connection with the collateral loss breakdown chart, per our information, and I don't want to make today about the Gemini data. That's not what today's about, Judge. But using the Gemini data, we thought the one liquidation was not even authorized. And so now, whatever the sum that Your Honor rules should have been put in by BlockFi, that has a downstream effect, and we have to capture that. And in capturing that, Your Honor, we think we should look at it with fresh eyes, utilizing this expanded record, which includes the handbook, and also includes some additional consideration of specifically the type of discretion that BlockFi was allowed to employ. Because most respectfully, Judge, as we read the court's findings as to discretion previously, to us it seemed almost this unbounded discretion. And so part of the additional material that was included in Mr. Van Tubergen's most recent certification and in the submission, it just meant to speak to this issue of it was not unbounded. And once we factor in that additional ETH should have been deposited, reinstated, then things would have looked even further different. And lastly, Your Honor, to me, the most consequential procedural aspect here is the district court surmising that it is indeed a reaffirmation transaction. To me, with that, we can then go back to Your Honor's initial finding that Mr. Van Tubergen's math, in terms of his assessment of the financial structure of the subject LSA, that it made sense. Well, if we connect those two, Judge, to me, I think that results in a finding in favor of Mr. Van Tubergen. So those are my points at this moment, Your Honor.
All right. Before I turn to Mr. Ouellette, does counsel agree on the choice of law? In other words, what the court is being asked to do is interpret several agreements. Do we agree on which law applies? Delaware, New York, New Jersey. Let me turn to you, Mr. Magalhaes. What law am I applying?
Well, I know in some respects it's Michigan law, Judge. This
my recollection in other BlockFi matters that we were applying Delaware law. As far as in some of the account agreements. But before we leave the call, I want to get a sense on what to the extent it makes a difference, and it may not make a difference as far as contract law interpretation.
Judge, I don't mean to be coy. I'll obviously let Ken speak. On that, it may be too consequential an issue. And on that, I would potentially request supplemental briefing, but I don't want to get ahead of myself.
All right. Well, let me hear from Mr. Ouellette. Thank you. Thank you, counsel. Mr. Ouellette.
Your Honor, the E43 LSA, which I think is the key LSA in this, states that the laws of the state of residence of the borrower will govern, but the agreement will be governed by federal law. Apology. So, I don't dispute that Michigan law likely applies.
So it is Michigan law?
Yes.
All right. Then, Mr. Ouellette, let me have you respond, supplement your reply in any fashion.
Sure. Thank you, Your Honor. Kenneth Ouellette for the Plan Administrator for the record. Your Honor, our objection said that Mr. Van Tubergen had, two paths, and neither of them led to him winning, and that he had to essentially pick one. In his response, he did pick one, and I went back and looked, and both Mr. Van Tubergen's certification and his opposition are very clear that they are seeking to exclude the emails in their entirety. And I quote on paragraph 19, the subject LSA's integration clause, section 5A, 4 thereof, should be given effect to preclude the introduction of outside materials, in this case, emails. So, look, the pleadings say what they say, and I think that Mr. Magalise's comments are an acceptance that if the E43 LSA is the only document and the integration clause applies, there is nothing in there that gives Mr. Van Tubergen any entitlement. Section 5 of the LSA is very clear that it is on the borrower to deliver the collateral. There is no obligation in the LSA for BlockFi to deliver the collateral. There is no statement in the LSA saying that the collateral has been delivered. The LSA is drafted in such a way that it can be signed and then the collateral deposited. A borrower could default by simply failing to deposit the necessary collateral. So under the LSA, giving effect to the integration clause, Mr. Van Tubergen loses because the ETH was never posted. It doesn't even matter why the 4,230 is there, because it's just not an obligation of BlockFi. I understand the comments to be that we are shifting back to looking at what I'm going to call the June emails. And here, look, you will hear from Mr. Magalise's comments and from the filings, it is clear that there is only one thing that they want this court to focus on, and that is the subject line of the email, because the terms of the email are very, very clear on what BlockFi is proposing. Remember, this court and the district court have already ruled that Mr. Van Tubergen's claims that the previous liquidations were wrongful are without merit. And I'm going to just disregard a surprisingly large amount of pleading that goes to that and simply focus on the issues here today. The agreement that BlockFi proposed was quite simply, we will lend you the money to borrow the ETH that was liquidated. It was not an admission of guilt. It was not an admission that there was anything wrong with it, but that Mr. Van Tubergen really wanted to have that particular exposure, and BlockFi could provide what it called a one-time accommodation to give him that economic exposure, but it was very, very risky. And BlockFi goes into detail about why it's risky, because Mr. Van Tubergen is going to have a loan that, when you apply how the structure works, which is nobody's giving Mr. Van Tubergen anything, he is borrowing the money to go out and buy that ETH. And so the loan is going to be originated at a very risky level, close to liquidation. At the time that the email was sent, it would have been 79%. I think we say in our response that as it was eventually originated, it was about 76%, both very risky. But let's go back to, essentially the district court's view of the world, which was, does Mr. Van Tubergen have a claim because the June email says that he is that BlockFi is offering to purchase 1,584 ETH, but only purchased 1,320 ETH. Does Mr. Van Tubergen have a claim for that missing 264 ETH? And the answer is no. And Mr. Van Tubergen essentially admits that. But the reason is because nobody was offering to give Mr. Van Tubergen it. This was not a settlement in the email where BlockFi was offering to pay Mr. Van Tubergen money to give him any sort of cryptocurrency. It was offering him a new loan product. And so had Mr. Van Tubergen borrowed the 1,584, had he bought that amount, he would have needed to borrow it. And in his certification on page 11, he admits this. He says, however, only 1,320 ETH was purchased, and only the purchase price of this amount was added to the loan balance. Had BlockFi purchased 1,584 instead, his loan balance would have been higher. Because when you add the same amount to the loan and the collateral, the loan to value rises slightly. For example, if you borrow $1 against $2 of collateral, and then you add that's a loan to value of 50%. You add $1 to the loan, you add $1 to the collateral, you have $2 of loans against $3 of collateral, or 67%. So at the end of the day, as we set forth in our opening argument and didn't reiterate in our reply because Mr. Van Tubergen pled the integration clause, unfortunately, the agreement on when and how much to purchase does not appear to have been done by email. Mr. Van Tubergen does not, testify in any credible way as to what happened, and we don't have a document to show you. But even if BlockFi was supposed to purchase more ETH, it was supposed to charge him more money. And so his damages under that theory are zero. I'm going to go finally to what I said about Mr.
Let me just stop you for a second, Mr. Olin.
Sure.
Well, the email, the June 29th email from BlockFi, which was confirmed in the June 30th email, references the purchase of 1565.24, and that's where the district court looked, I think, that's where we come up with the 245 ETH difference as opposed to 265. Where's the larger number, the 1584 number, come from that you just referenced?
I'm sorry, I meant the 1565.
Okay.
If you look, I got my numbers wrong. Apologies. Your
Because
Honor,
I do see it in your reply. There's another reference in paragraph. Let me see if I can find it. Paragraph 69, for instance, says 1584. BlockFi originally offered to purchase 1584 ETH. We're talking about 20 or so ETH. I'm just curious to where. I was trying to find where those numbers were coming from. I didn't see it in the email. Mr. Van Tubergen, smiling, he seems to know.
I apologize, Your Honor. That is likely an error on my part.
Okay. So, but the emails clearly say 1565.
Yes.
0.2442. All right, let me continue. I interrupted you.
So what I said about Mr. Van Tubergen in his certification appears to argue that notwithstanding the June 29th and June 30th emails, that at some point between then and the LSA, BlockFi agreed that it would actually purchase enough to bring him up to 4,230. And that is just not credible. First of all, because that's not consistent with the structure of the deal laid out in the email. He would have had to borrow far, far more than he did in order for BlockFi to purchase that under this structure. So it would need to be BlockFi was giving him a very large amount of cryptocurrency for free, essentially. And there, he consistently pleads that the entire reason for this was a quote-unquote reinstatement transaction, of what we refer to as the A5 LSA. And the A5 LSA is attached to his original objection, or his original response as Exhibit B. And if you look at that, the A5 loan has a collateral of 3,047. The record shows that he later pledged about a little over 500, I think less than 600, ETH to try and meet the margin call on the A5 loan, but was not in time. That's where you get the total of 3,580 ETH referred to in the June 29th email. At no point did Mr. Van Tubergen ever have 4,230 ETH on the system. To reinstate his loan, if BlockFi had actually said, you know what, we're wrong, we should give you your collateral back, 4,230 has nothing to do with that amount. And so Mr. Van Tubergen's testimony that somebody agreed to this with no documentation whatsoever is just not credible. So at the end of the day, there's only two paths. There's the path where the integration clause is enforced and the E43 loan says what it says, and what it says is that Mr. Van Tubergen is responsible for posting the collateral. He didn't post $4,230. He's not entitled to any collateral that he didn't post. BlockFi did choose to purchase and contribute that collateral and loan him the money to do so, but the E43 LSA has the standard clause that says if we choose to waive some of our rights under this agreement, that waiver is limited to what we actually did. Under the other path, we look to the actual email that Mr. Magliese today wants to focus on as BlockFi's offer. And that's fine too. And there, as we laid out in our opening papers, it's very clear that he just does not have a claim. It would be great if we had the email where he confirmed that he wanted a lower amount, but the email on the 30th says that he will identify both a safe purchase price and a safe amount. And the structure of the loan, and Mr. Van Tubergen admits this, BlockFi bought 1,320 ETH and charged him for that amount. Had they bought more, they would have charged him for it, and so there is no damage, because the only effect would have been he would have hit that liquidation point just a little bit earlier. There's only a couple other points. Going to damages, Your Honor, as I expect you to expect, we don't believe that you need to go to damages, but should you, Section 502B is unambiguous. If Mr. Van Tubergen has a claim for missing ETH, it is valued as of the petition date, just like every other claimant in this bankruptcy. He attached the, quote, the BIA claim form and said, well, I'm not a BIA creditor. The loan claim form has the same amount because it's not about the type of claim. It's about, are you an unsecured creditor? He is an unsecured creditor. Any claim would be valued at the petition date, Section 502B. The consequential damages are, look, frankly, his theory on this is incomprehensible. It appears to be that he pleads every single liquidation after this point is the damages from this loan. But number one, he's already lost on all of those. His argument that all of those are improper. Number two, there's not a claim for that in the claim form. And number three, he explicitly waives that in the June 29th email, where he agrees BlockFi shall not be liable for any damages or any loss caused as a result of this transaction. At the end of the day, Mr. Van Tubergen had one discrete issue remanded back from the district court. He filed a claim for $10 million on a whole panoply of claims. He's gotten one chance to replead this issue, which has a maximum value of about $1,044,000. He's tried to make that into $7.5 million, which is, spending again half of his pleading relitigating the issues that he already lost. Last, there is a sort of throwaway request for a reserve to be set. I think that's just not proper at this time. Once the court issues a ruling on this, if a reserve would be appropriate, Mr. Magliese can file a motion either seeking a stay of the order or seeking a reserve to be set. He doesn't provide a dollar amount or basis for the reserve. There's nothing really the wind-down debtors can respond to on that point.
All right, I have a quick question or two, Mr. Ovett. So I'm looking at E43, the LSA, and nobody seems to contest that the amount of the loan, the restructured loan, is $5,982,830.21. And my understanding is that that's comprised of the balance that was owed at the time of $2,759,717, and then new credit of $3,169,112, which, and I'll ask Mr. Ouellette if you confirm, to me seems to be 1,320 ETH at roughly $2,400 per ETH. My question is, what was the basis for BlockFi to extend the 3,169,112? How is that number reached? Was there an agreement to buy a certain amount of ETH? And then whatever that is, that's going to be the new loan? Or was there an agreement on the loan amount and we'll purchase as much ETH until we hit that loan amount? The 3 million, the new additional amount. In other words, is there anything in the record or anything you can point to that tells me how the 3,169,000 figure was reached? Because obviously, in that same document, there's 4,000 provides for 4,230.12 of ETH as collateral, and speaks to a loan-to-value ratio of 60%. Now, granted, the June emails did not speak to 60% loan-to-value, traditional for. It spoke to a riskier loan, which would suggest that there would not be as much ETH as the 4,230. But trying to get a sense of, was it the cart before the horse before the cart, or the cart before the horse? How was that $3,169,000 number added to the prior balance reached? Was that a customer request or a BlockFi dictate? Mr. Ouellette, I know Mr. Magalas wants to raise his hand, but I turn to you first.
So, Your Honor, unfortunately, we don't know, because as I said, the June email is the only thing we have in writing, and we have Mr. Van Tubrien's testimony that doesn't match either of the options. So we're trying to be forthright that we don't know why the amount differs from what's set forth in the email, if there was a decision to cap the amount or cap the ETH. However, what we'd submit is that it's very clear how you get to the amount that's being added. One way or another, Mr. Van Tubrien is borrowing all the money to pay for the new ETH.
But I'm correct, that 3,169,000 figure reflects the cost to BlockFi in acquiring the 1,320 ETH.
Yes, Your Honor.
Okay. Mr. Magalas? Oh, you're not on. Your speaker's not on.
So, Your Honor's already seen our mathematical computations. You saw it the first time. You've seen it again. Judge, I have to rely on that the same way I would if I retained an accountant and they did it, right? I know my client knows these numbers better than anyone. But I was actually going to say, and I don't want to violate the rules of order here, but when Becca asked us if we had testimony to offer, I said, well, Mr. Van Tubrien will make himself available, and I think this could be an opportunity for the court to ask the question to my client, because I have a sense that he's going to give the court a very clear answer.
Your Honor, I'd say that he already testified and that it's on page 11 of his certification that he says, however, only 1,320 ETH was purchased and only the purchase price of this amount was added to the loan balance. I don't think we need further testimony from him on that point.
I'm not going to have, respectfully, any more testimony. I don't want to open that door. I've lived with you all. We had mediations. I'm just doing the best to confirm what the record reflects.
So to that, Judge, I get it. And to that, I would just respectfully respond by saying that I think the numbers are truer than any words Mr. Van Tubrien could offer. So to the extent that those words, that he did trip over those words, then we would still rely on the mathematical computations coupled with his testimony that there were phone calls after the emails up until the date that the LSA was signed. And I know, rightfully so, the court's drilling down on the numbers, and I appreciate that. But when you step back, Judge, remember, the first ruling came down on Scrivener's error. It's becoming increasingly clear that so much focus was on the collateral amount. And that belies the notion that it could have been Scrivener's error. There was a huge spotlight on this. To us, common sense dictates that by the time the LSA was ready to sign, the parties were aware what type of transaction it was, a reinstatement transaction, and they would have known to scrutinize the amount of collateral. And so, it just, anyway.
So, all right, thank you. Mr. Arlett, I want to go back to you with a question. Let's accept that the LSA is what it says, and it was sent to Mr. Van Tubergen, and he sees that he's now responsible to pay $5,928,830.21, and he sees a loan-to-value ratio of 60%, I believe, and he sees that there's collateral, even if he didn't put it all up, of 4230.12 in ETH. He would not, just looking at that document, expect there to be any liquidation, any default or forced liquidation until it dropped below the 60%. Correct? So what unfolded from July 7th on, the date of the execution of the LSA? What opportunities was there for Mr. Van Tubergen to say, wait a minute, there's 4230 there, or for BlockFi to say there's not 4230 there?
So first, Your Honor, I would push back a little on the premise of the question. The LSA does not say that 4,230 has been posted.
No, it says it's to be pledged.
Right.
I understand.
So Mr. Van Tubergen got margin calls on this loan, which would have laid out, and I believe they're in the record. Unfortunately, look, this is the previous record, so I'm not exactly sure what they are. But it would have gotten the calculation of the margin call. You owe the 5.9 million. You have X amount of collateral. It's valued at X. You have 72 hours, because I believe in this, the initial threshold was 80.
Right.
That you have, actually, I'll also go back to one thing. It says, look, that he's got to keep a loan-to-value ratio less than or equal to 80%, and that's on page 5. The 60% number is in there as sort of the what he has to bring it to when the margin call is hit. But it's when he hits 80%, he gets a margin call. He has 72 hours to get the loan-to-value ratio into the proper amount, and that would have information on how much margin you have. He could have disputed it at that point, saying, hey, I have more collateral there than you show here. I don't think that any evidence to that has been put into the record. Mr. Van Tubergen has not testified that he called up BlockFi and said, what are you talking about? There's another almost 900. There's no emails that I've seen to that effect.
When BlockFi, let me just ask, when BlockFi issued the first margin call because it fell below the 80%, did it do so on the basis of the collateral being the 42 number, the 4200 number, or the 3334 number pledged?
The 3334 number pledged. Because remember, Your Honor, the amount of collateral can vary over the time of the loan, most often when additional collateral has been posted.
How would the customer here, Mr. Van Tubergen, have known that it was being based on that figure and not what was in the LSA?
I'd have to go back to see if the actual emails were in the record and take a look. But it's, as Mr. Van Tuveren said, it's a mathematical calculation. He could go, the price of ETH on any particular day is a Google search away. He could have done a Google search and seen this doesn't make sense, even if the margin call email didn't have sufficient information for him to look at it and immediately see BlockFi sees only 3,300 ETH, not 4,200 ETH.
All right. I don't have any further questions. Ms. Rowlett, I'll give you anything else you wish to add?
No, Your Honor.
Mr. Magalhaes, anything you wish to add?
I know you've read the papers, Judge, and you gave me an opportunity to do a sole reply, which I appreciate.
All right. Then I'm going to take the matter under reserve, and I will issue a written opinion hopefully some point in the near future. All right. Out of curiosity, what's pending in the district court? Is the motion for reconsideration still pending?
Yes, Your Honor.
Have you had oral argument?
No, Your Honor.
The wind-down debtors have not been asked to respond, Your Honor.
Okay.
We're not able to respond unless asked.
All right, so that's not coming down the next day or so. So I'm just trying to get a sense what's out there. All right, I thank you all for your time and for your submissions. Take care.